So constitutional commissions, independent constitutional commissions, there's just three: the Civil Service Commission, CSC, the Commission on Elections or COMELEC, and the Commission on Audit or COA. So they are equally preeminent in their respective spheres. Neither one may claim dominance over the others. So in case of conflicting rulings, it is the judiciary which interprets the meaning of the law and ascertains which view shall prevail. So again, the three ConComs are CSC, COMELEC, and COA. And the grant of a constitutional commission's rule-making power is untouchable by Congress, because again, these constitutional commissions are independent. So absent a constitutional amendment or revision, Congress cannot even encroach upon these commissions. However, the laws that the commission interprets and enforces fall within the prerogative of Congress. As an administrative agency, its quasi-legislative power is subject to the same limitations applicable to administrative bodies. So again, diba, the Congress, they create the laws. So COMELEC implements these election laws, for example, but the election law is really within the province of Congress because they have the lawmaking power. So what are the constitutional safeguards to ensure the independence of commissions? So first, these commissions are constitutionally created. Hence, Congress cannot abolish these commissions even by statute or by law. So the only way to abolish these commissions, CSC, COMELEC, and COA, is if you amend the Constitution or you revise the Constitution rather, because amendment is too small of a change. It needs revision because constitutional commissions are a major thing in the Constitution, or a fundamental it would constitute a fundamental change that is tantamount to a revision, not an amendment. So again, first, they are constitutionally created, cannot be abolished by law. Second, each commission is vested with powers and functions which cannot be reduced by statute. So even if Congress will pass a law, for example, an election law, like an amendment or a revision of election law or a new election law, there are certain functions and powers that are stated in the Constitution that governs these constitutional commissions that even laws passed by Congress cannot reduce. And of course, they are independent constitutional bodies. They have a certain autonomy. Even the chairman and the members of such constitutional commissions cannot be removed except by impeachment. And they have a fixed term of office of 7 years with a rotational scheme, staggered terms. When you say rotational scheme, meaning hindi sa sabay-sabay tanggalin. Rather, there's continuity, because there will always be a member of that CONCOM that would remain even if the other members are changed. So the chairman and members of a CONCOM may not be appointed in an acting capacity, and their salaries may not be increased during their tenure. But the commissions enjoy fiscal autonomy. They have their own budgets. And each commission may promulgate its own procedural rules provided they do not diminish, increase, or modify substantive rights involved. And the commission may appoint their own officials and employees, but it must be in accordance with the civil service law. So Section 1, paragraph 2 of Article 9D does not prohibit a promotional appointment from a commissioner to a chairman as long as the commissioner has not served the full term of 7 years, and the appointment to any vacancy shall be only for the unexpired portion of the term of the predecessor, and the promotional appointment must conform to the rotational plan or staggering of terms in the commission membership. So more on this later in terms of like the staggering terms. So the terms of office of commission members. The term of the first chairman and commissioners of the ConComs back in 1987 Constitution started at a common date. So They started a common date, respective variations of the dates of appointment, and qualifications of the appointees, in order that the expiration of the first terms of 7, 5, and 3 years should lead to the regular recurrence of a 2-year interval between the expiration of the terms. So, to start, now the term is 7 years. Pero sa first batch of commissioners and chairman, there were commissioners na 7 years yung term, iba 5 years and 3 years. That is to ensure the rotational scheme or the staggering of terms. But after that, tig 7 years na. Para once mag-expire na yung 3 years, papalitan, and then there would be yung papalit dun sa may 3 years na initial na term, may 7 years term. So, lahat na sila eventually may 7 years, pero hindi sila sabay-sabay mag-expire. So, there will always be someone from the old set who would be there sa new set of commissioners. So, there's always a senior commissioner member for continuity. The term is the time during which the officer may claim to hold office as of right and fixes the interval after which the several incumbents shall succeed one another, while tenure is the time during which the incumbent actually holds and exercises the office. So the term of office is not affected by the holdover, and the tenure may be shorter than the term for reasons within or beyond the power of the incumbent. So when we say term, that's the maximum allowed time, or the set time, or the set time in which the person holding the office may have authority to exercise such office. So for example, for commissioners, they have 7 years. So that's the term, 7 years. It's always fixed regardless of the person sitting. Tenure is the actual time that the term of office was served. So for example, there's a 7-year term, and then the commissioner served for only 4 years because during the for example the 5th year, before completing the 5th year of office, for example, such commissioner died, so can no longer serve the full 7-year term. So the actual tenure of the commissioner is the 5 years wherein he actually served the office, but the term of office remains as 7 years. It's always going to be 7 years. So that's the difference between term and tenure. So for the first commission, Constitutional Commission, we'll talk about the Civil Service Commission, or the CSC, and it's a central personnel agency of the government. So the CSC has broad authority to pass upon all civil service matters. It's like the HR of the government, or the manning agency of the government. The mandate of the CSC should therefore be read as the comprehensive authority to perform all functions necessary to ensure the efficient administration of the entire civil service, including the Central Executive Service, or the CES, and further the specific powers of the CESB, which must be narrowly interpreted as exceptions to the comprehensive authority granted to the CSC by the Constitution and relevant statutes. So as to the scope, it embraces all branches, subdivisions, and instrumentalities and agencies of the government, and that includes GOCCs with original charters. It does not include GOCCs which are organized under the General Corporation Law. So what are the examples of this? For example, University of the Philippines has an original charter and is part of the CSC still. So jurisdiction, in terms of jurisdiction, the CSC has been granted by the Constitution and the Administrative Code jurisdiction over all civil service position in the government service, whether it's career or non-career. In terms of like appellate jurisdiction, the appellate power of the CSC will only apply when the subject of the administrative case filed against erring employees is in connection with the duties and functions of their office, and not in cases where the acts of the complainant arose from, say, cheating in civil service examinations. In administrative disciplinary cases decided by the COA, the proper remedy in case of an adverse decision if an appeal to the is an appeal to the Civil Service Commission, and it is not a petition for certiorari before the Supreme Court under Rule 64. So the Philippine National Red Cross, although it's not a GOCC, is sui generis in character. So when you say sui generis, it means a specific kind, or a kind, a special kind, a specific kind, a classification of its own. So it's sui generis in character, and the character of the Philippine National Red Cross requires the courts to approach controversies involving the Philippine National Red Cross on a case-to-case basis because it's sui generis. So since the issue involves the enforcement of labor laws and penal statutes, the Philippine National Red Cross can be treated as a GOCC, even if it's not. Thus, if it's treated like a GOCC, then the Civil Service Commission has jurisdiction. Moreover, the CSC has appellate jurisdiction on administrative disciplinary cases involving the imposition of a penalty of suspension of more than 30 days or fine in an amount exceeding 30 days' salary. So what are the functions of the Civil Service Commission, or CSCC? First is to implement various laws governing appointments to or even removals from, discipline and benefits within the civil service. Under the Administrative Code of 1987, the CSC has the power to hear and decide administrative cases instituted before it directly or on appeal, including contested appointments. The CSC also has original jurisdiction to hear and decide a complaint for cheating in the civil service examinations committed by government employees. So if hindi pa sila government employees, then the CSC has no jurisdiction over them. But once they become government employees, then the CSC has jurisdiction over them. So it is the intent of civil service law in requiring the establishment of a grievance procedure that decisions of low-level officials in cases involving personnel actions be appealed to the agency head first, then to the Civil Service Commission. So those are the functions of the CSC. They have the power to implement the rules, they have the power to appoint, to remove, to discipline, to grant benefits to government employees, basta government employees lang, to hear and decide cases, administrative cases brought before it, even has appellate jurisdiction, and so they have quasi-legislative and quasi-judicial functions. So classes of service is characterized by entrance based on merit and fitness to be determined as far as practicable by competitive examinations, or based on highly technical qualifications with opportunity for advancement of higher career positions and security of tenure. That's why there's a civil service exam. It could be prof or non-prof, they say, professional or non-professional. So those are two different exams depending on the position you want to apply to. So you have to pass the civil service exam first before you can become a government employee technically. So there are people working for the government that are not civil service exam passers. Yes, but there are certain positions that require someone to pass the civil service exam in order to be entitled to such position. So there are certain positions that need a civil service exam, that needs one to pass a civil service exam before they can be qualified to such position. So the classes of service, the civil service, are first open career positions where prior qualification and appropriate examination is required. Then we have closed career positions, very scientific or highly technical in nature. The career executive service, this is for undersecretaries, peer directors, or their equivalent. Career officers, other than those belonging to the career executive service who are appointed by the president. So it's also possible that you are appointed by the president. Certain positions depend this position, that even if you are not the civil service passer but you were appointed by the president, then okay. Another is if you're a member of the bar of the Philippine bar, if you're a lawyer who already passed the bar exams, of course you have to pass the bar exams to be a lawyer, then you're not required actually to pass the civil service exam. Passing the bar exam already qualifies you for civil service, so you don't need to take the civil service exam. Positions in the Armed Forces of the Philippines, so it's governed by a different merit system, but there are positions there that the civil service has jurisdiction, or that is governed by the Civil Service Commission. Personnel of GOCCs with original charters, permanent laborers, whether skilled, semi-skilled, or unskilled. So for non-career service is characterized by entrance based on something else other than those of the usual test utilized for the career service, so not the civil service exam, and their tenure is limited to a period specified by law, or which is coterminous with that of the appointing authority or subject to its pleasure of the appointing authority, or which is limited to the duration. So these non-career service positions are elective officials, okay, and their personal and confidential staff, because of course they don't need the civil service exam, they just have to be elected for the position through suffrage or the election system. Department heads and officials of cabinet rank who hold office at the pleasure of the president, and their personal and confidential staff, of course they don't need the civil service exam because they just have to be appointed by the president. Chairmen and members of commissions and bureaus with fixed terms, contractual personnel, emergency and seasonal personnel. So except as otherwise provided by the Constitution or by law, the Civil Service Commission shall have the final authority to pass upon the removal, separation, and suspension of all officers and employees in the civil service, and upon all matters relating to the conduct, discipline, and efficiency of such officers and employees. So appointments in the civil service, the role of the CEC in the appointing process is limited to the determination of qualifications of the candidates for appointments and plays no role in the choice of the person to be appointed. As a general rule, appointments are made only according to merit and fitness, to be determined as far as practicable by competitive examination. But there are, of course, exceptions, which are policy determining, where the officer lays down principal or fundamental guidelines or rules, or formulates a method of action for government to any of its subdivisions, if it's primarily confidential, denoting not only confidence in the aptitude of the appointee for the duties of the office, but primarily close intimacy, which ensures freedom of intercourse without embarrassment, or freedom from misgivings or betrayals on confidential matters of the state, and highly technical, which requires possession of technical skill or training in supreme degree. So now for the disqualifications. No candidate who has lost in any election shall within 1 year after such election be appointed to any office in the government or any GOCC or in any of its subsidiaries, and no elective official shall be eligible for appointment or designation in any capacity to any public office or position during his tenure. Unless otherwise allowed by law or by the primary functions of his position, no appointed official shall hold any other office or employment in the government or any subdivision agency, or instrumentality thereof, including GOCCs or their subsidiaries, and no officer or employee in the civil service shall engage directly or indirectly in any electioneering or partisan political activity. So as to removal or suspension only for cause, no officer or employee of the civil service shall be removed or suspended except for cause provided by law. So now let's talk about the chairman and the commissioners. So the composition of the CSC, it's composed of one chairman, of course, and two commissioners only. So there's just three of them. And the following are their qualifications. They must be natural-born citizens of the Philippines, and at the time of their appointment, they are at least 35 years of age. They must have proven capacity for public administration, and they must not have been candidates for any elective position in the election immediately preceding their appointment. So they could be candidates for elective offices sa previous elections, as long as that election is not immediately preceding their appointment, not the last election that was conducted. So in terms of term of office, which was already discussed, 7 years, except for those first appointed, because sa first appointment, first batch of the members of the CSC, the chairman 7 years, and then the one commissioner served for 5 years and the other for 3 years. But for the next batches, tig 7 years na each. So now let's talk about COMELEC, or Commission on Elections. So the functions of COMELEC. First is to enforce all laws relating to the conduct of election, plebiscite, initiative, referendum, and recall. To recommend to Congress effective measures to minimize election spending and to prevent and penalize all forms of election frauds, offenses, malpractices, and nuisance candidacies. Submit to the President and Congress a comprehensive report on the conduct of each election, plebiscite, initiative, referendum, or recall. So again, election, when you elect public officials. Plebiscite is when there is something that is required to be voted upon by the people. Initiative is petition from the people themselves. A referendum, and recall is when the people want to remove the person they elected. So another function of the COMELEC is to decide administrative questions pertaining to election, accept the right to vote, declare failure of elections. It's also one of their functions. To file petitions in court for inclusion or exclusion of voters, to investigate and prosecute cases of violations of election laws, recommend pardon, amnesty, parole, or suspension of sentence of election law violators, to deputize law enforcement agencies and instrumentalities of the government for the exclusive purpose of ensuring the free, orderly, honest, peaceful, and credible elections. So they can also seek help from other agencies of the government. Registration of political parties, organizations, and coalitions, and accreditation of citizens' arms. Regulation of public utilities and media of communication or information, and decide on election cases. So those are their functions. Now, there are divisions in the COMELEC. So the divisions here, certain cases brought before them, election contests such as proclamation, controversies, recounts, and the like are decided first by division. Then the N-Bank as a whole, meaning all of them, only decides motions for reconsideration of those election contests. But in all other instances, if it's not a pre-proclamation controversy, it's not a petition for recount and the like, then the COMELEC will act en banc, meaning all of them, not by division. So exclusive jurisdiction, all contests relating to the elections, returns, and qualifications of all elective, regional, provincial, and city officials. Currently, the enforcement of election laws may be concurrent when Congress assigns such enforcement to a different body. So jurisdiction over intra-party disputes. The COMELEC's powers and functions under the Constitution include the ascertainment of the identity of the political party and its legitimate officers responsible for its acts. So the power to register political parties necessarily involves the determination of the persons who must act on its behalf. Thus, the COMELEC may resolve an intra-party leadership dispute in proper case brought before it as an incident of its power to register political parties. Now, for the COMELEC's appellate jurisdiction, all contests involving elected municipal officials decided by trial courts of general jurisdiction or involving elective barangay officials decided by a court of limited jurisdiction. What is this limited jurisdiction? Limited jurisdiction to issue writs of certiorari. Interpreting the phrase in aid of its appellate jurisdiction, if a case may be appealed to a particular court or judicial tribunal or body, then said court or judicial tribunal or body has jurisdiction to issue the extraordinary writ of certiorari in aid of its appellate jurisdiction. Hence, the COMELEC may take cognizance of a petition for certiorari questioning an interlocutory order of the RTC in an electoral protest case. So as to the composition, the CSC had 3 members, the chairman and 2 commissioners. In COMELEC, there are 7 of them. So the chairman and 6 commissioners. My professor used to say that there's like a technique to remembering how many members for each commission. So you just base it on the letter of the acronym of the constitutional body. Like for example, CSC. So there's 3, of course, 2 commissioners, and there should always be 1 chairman. For COMELEC, COMELEC, so that's 7. Of course, 1 is chairman, so you have 6 commissioners left. And of course, for COA, there's 3 letters, COA. So there's 3 members, 1 is commissioner, and 1 is chairman, and 2 commissioners. So that's the tip. Now for the qualifications of the members of the COMELEC. Okay. So first, they must be natural-born citizens of the Philippines, just like in the CSC, and at the time of their appointment, also at least 35 years of age. They must be holders of a college degree. This is absent in the qualifications for the CSC. And CSC, you don't have to be a college graduate, just someone with proven competence in public administration. But if you're a member of the COMELEC, you must be a college graduate. Must not have been candidates for any elective position in the election immediately preceding their appointment, similar to the qualification for members of the CSC. And the majority of the members, including the chairman, must be members of the Philippine Bar who have been engaged in the practice of law for at least 10 years. So members of the COMELEC must be, well, not all of them, but majority of them must be lawyers. And for you to be a chairman of COMELEC, you must be a lawyer. So that's one special qualification. In the CSC, you don't have to be a lawyer. You don't even have to be a college graduate. But if you want to be the chairman of COMELEC, you have to be a lawyer. If you want to be a COMELEC commissioner, you must be at least a college graduate. But majority of you must be a lawyer. So if there's 7 of them, then at least 4 of them, including the chairman, should be a lawyer. So at least 3 of the commissioners should be lawyers, and the other 3 pwedeng hindi lawyer as long as college graduate. So as for term of office, 7 years, except those first appointed, staggered. So 5, 7, 5, 3 yung first batch. So let's go to COA, or Commission on Audit. The COA examines, audits, and settles accounts pertaining to government funds or property, its revenue, receipts, expenditures, and uses. So the local government units or LGUs, though granted local autonomy, okay, are still within the audit jurisdiction of the COA. So, post-audit basis, complementing the constitutional power of the COA to audit accounts of non-governmental entities receiving subsidy or equity directly or indirectly from or through the government is Section 11, Paragraph 1 of Book 5 of the Administrative Code, which authorizes COA to audit accounts of non-governmental entities required to pay or have a government share, but only with respect to funds coming from or through the government. So as long as they receive some funds or funding from the government, then they may be audited by COA. So examples of these bodies or entities that may be audited by COA are: first, constitutional bodies or commissions and offices, autonomous state colleges and universities, GOCCs with no original jurisdiction, with no original charters and their subsidiaries, non-governmental entities receiving subsidy or equity directly or indirectly from or through the government, which are required by law or the granting institution to submit such audit as a condition of subsidy or equity. And the COA's audit jurisdiction does not allow it to interfere in how the Supreme Court appraises the value of properties that can be purchased by its retired justices, as this would be an interference in the judiciary's final autonomy, however. So as to exclusive authority, the COA has the following exclusive authorities. First is to define the scope of its audit and examination, establish techniques and methods required, and to promulgate accounting and auditing rules and regulations. And this includes giving the COA Assistant Commissioner and General Counsel the authority to deputize a special audit team. No law shall be passed exempting any entity of the government or its subsidiaries in any guise whatsoever or any investment of public funds from the jurisdiction of the Commission on Audit, and the Congress cannot exempt foreign grants from the jurisdiction of the Commission on Audit. Its jurisdiction extends to all government-owned or controlled corporations, including those funded by donations through the government. So primary jurisdiction over money claims is limited to liquidated claims because the COA has primary jurisdiction to pass upon a private entity's money claims against a provincial government. However, the scope of the COA's authority to take cognizance of claims is circumscribed by cases holding statutes of similar import to mean only liquidated claims or those determined or readily determinable from vouchers, invoices, or such other papers within reach of accounting officers. The COA has no jurisdiction over validity or constitutionality of over money claims against government. The jurisdiction of the COA over money claims against the government does not include the power to rule on the constitutionality or validity of such money claims. So as to the ruling, COA does not have the jurisdiction to determine whether it is constitutional or valid or any imposition. So just their jurisdiction is limited to money claims but not to its constitutionality or validity. So composition of COA, again, there's 3 COA, chairman and 2 commissioners. So the qualifications, again, natural born citizens of the Philippines at the time of their appointment, at least 35 years of age, and they must be certified public accountants, CPAs, with no less than 10 years of auditing experience. Or, pwedeng hindi sila CPA but they must be lawyers or members of the Philippine Bar with at least 10 years practice of law. So either CPA, CPA lawyer, or lawyer, as long as they have 10-year experience in their respective fields, with proven capacity for public administration, and must not have been candidates for any elective position in the election immediately preceding their appointment. Term of office also 7 years, except those first appointed. Now, for prohibited offices and interests, no member of the Constitutional Commissions, whether CSC, COMELEC, or COA, shall during their tenure hold any other office or employment. This is similar to the prohibition against high executive officers. It applies to both public and private offices and employment. They can't hold another public office or a private office. They have to focus in their duties when they are members of the constitutional commissions. They cannot even engage in the practice of any profession, including their own. They cannot engage in the active management or control of any business which in any way may be affected by the functions of his office. I guess they can invest, but they can't become managing directors or CEOs of a company. They cannot be financially interested directly or indirectly in any contract with or in any franchise or privilege granted by the government, subdivisions, agencies, or instrumentalities, including GOCCs or their subsidiaries. So the CSC chairman cannot be a member of a government entity, for example, that is under the control of the president without impairing the independence vested in the CSC by the 1987 Constitution. So again, they can't hold any other office apart from their office and their respective constitutional commissions. Now, for judicial review, final orders, resolutions, and decisions of constitutional commissions surrendered in exercise of quasi-judicial functions, each commission shall decide by a majority vote of all its members, not only those who participated in the deliberations, but any case or matter brought before it within 60 days from the date of its submission for decision or resolution. Any decision, order, or ruling of each commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from the receipt of the copy thereof. In resolving cases brought before it on appeal, the respondent, Constitutional Commission, is not required to limit its review only to the grounds relied upon by a government agency. Say, for example, in COA, the government agency's auditor with respect to disallowing certain disbursements of public funds, for example, because such would render COA's vital constitutional power unduly limited and thereby useless and ineffective. So, certiorari jurisdiction of the Supreme Court. So, for final orders in the exercise of Commission's quasi-judicial functions, it is limited to decisions rendered in actions, proceedings taken cognizance by the Commission in the exercise of their quasi-judicial powers. The Court exercises extraordinary jurisdiction. Thus, the proceeding is limited only to issues involving yung alleged grave abuse of discretion resulting or amounting in lack or excess of jurisdiction, and does not ordinarily empower the court to review factual findings of the Commission. So when you appeal it to the court, certiorari Rule 65, you just the Supreme Court just determines whether there was grave abuse of discretion amounting to lack or excess of jurisdiction on the part of the Constitutional Commission or its members. So for interlocutory orders via Rule 65, still in a proper case. So as a general rule, the mode of review is a petition for certiorari under Rule 64 and not 65. However, the exception is that the rules of civil procedure, however, provides for different legal route in cases of Civil Service Commission or CSC. In case of CSC, however, Rule 43 will be applied and the case will be brought to the Court of Appeals instead of directly to the Supreme Court via Rule 64. decisions, orders, or rulings of the Commission and the exercise of their quasi-judicial functions may be reviewed by the Supreme Court. So, acts rendered in the exercise of administrative functions of a constitutional commission are not judicially reviewable. These are in the exercise of the Commission's discretion or prerogative, which are in the nature of policy and generally not reviewable by courts, but there are exceptions. And those are, first, when they are in violation of statutes or breach in civil law, they may be challenged to ordinary civil courts, civil actions rather, in the regular courts. And when there is a proper case and for grave abuse of discretion amounting to lack or excess of jurisdiction, then they may be challenged by certiorari on Rule 65. So that's it for COMELEC, COA, and CSC, or the Constitutional Commissions.